The, it is sensitive issue.
Sensitive issue.
The hospital.
Can we just give me 1 minute? I have not read it. Let me go through the prayers.
Paragraph 7.
In 2020,
No, I'm not just, you are challenging NIT is inviting tender.
yes,
On what ground?
now that my period is not over, that I'm bringing to office notice, please
Just
get
give
not
me-
for tax.
No, just show me the tender.
Tender is that is one of the
113?
yes, but I'm that is annexure 8113 madam.
Yes, the 113, that's why I
Yes,
say. It is for outsourcing of the security services.
Yes.
Health institutions.
Yes, that is on note 29 or 2020. This is the impugned order.
Not impugned order, this is a
So far,
NIT. NIT is concerned, they have floated.
floated and challenged it.
Now on what ground?
Yes. In 2020, we see the same advertisement of published. In 2020, then I was also an applicant. Then allegations of manipulation in then made. Then it was decided to cancel. Then my lord, inquiry was conducted, it was right. However, it was cancelled. I approached your lordship. Lordship said cancellation is bad. Then my lord,
Cancellation is
it
bad.
is bad. This honorable court held. Because no reason was given, nothing sought. Then my lord, it was decided to make me agreement with me, my lord, make an agreement with me. Then another person approached this honorable court, another candidate. And he got an interim order. Then it was never given, work was never given, no agreement was conducted. Then that writ application was dismissed. Subsequently, the last writ application that is dismissed.
When
It was dismissed on 22nd 9, 2023, page 102 is the main order.
dismissed by default,
No, on merit.
on merit, okay.
That it was in accordance with law. Tender was good, everything was discussed.
Then,
Then my lord, on 26/9, agreement was made that will be effective from 1/10/2023. Nothing can be done to
29 September, the agreement was entered into or executed.
entered into and
Yes, executed, operative from 1st October.
2023.
What was the duration?
In 3 years, what can talk to their advertisement page 25.
Correct. So it was in 2023.
23, 1/10/2023.
Correct.
Language is the engagement shall be for a period of 3 years from the date of actual operation beginning of service.
So that is 1st October.
First October. And second one, and my entire contention would be this the discriminatory or advertises upon. If you look at the history, all of them know, but always they have tried to cancel my tender. And period, apart from that, there is another guideline also. It can also extend it for 2 years, subject to satisfactory. All certificate
This is the contingent contract.
contract.
It's a contingent clause. You cannot assert your inchoate right or a vested right.
Exactly, ma'am. I'm entitled for consideration. If my What's a satisfactory?
It's a subjective.
So that was
It's a subjective.
for consideration. I may not get a right, but entitled for consideration is a right in terms of their arguments. Therefore, I have not completed 3 years. That will be completed on 1/10/2026. Before that, twice they are cancelled. Again, not seen interfered. This is third round. This is my entire case will watchable. Let's take a look at page 25.
Yes. Is there any earlier termination or a sooner determination clause in the agreement? Earlier termination or sooner determination clause?
Here we are at page 105.
What it says?
Clause 8.
What it says?
Termination, suspension of agreement.
What it says? Read it.
That copy is not legible. Oops, on bad space.
The soft copy is not legible. And how the hard copy will be legible?
Paragraph 5.
8.
8 is saying termination, suspension. The इसकी का third instant.
Yes. Have you issued any notice of earlier termination?
Let's kindly turn to Annexure 7. Annexure 7.
Each.
Page the relevant page at 111.
Yes, is that.
What happened actually when the agreement was in force, the government took a decision on 7/12/2020.
111 is a order of.
Yes. 7/12/2022 and decision was taken by the government. That is not the part of the record here, Millard. The government took a decision, Millard. All the contracts which are entered by the government, Millard, all has to be cancelled with prior notice. Notice was issued. Thereafter, this notice was challenged before this honorable court.
By whom?
By the petitioner. Petitioner Millard, that is WPC number 3585 of 2024.
So what happened thereafter? What is the fate of this?
Millard,
Is pending.
the said writ application is pending.
So
Millard,
Military order is also there.
may I pray, Millard, let that be tagged up with this matter, may be taken up tomorrow.
what are we talking about?
Tomorrow I am not available.
And in that writ application, Millard, this letter of the government dated 7/12/2023 is never dated. No amendment to that effect. I was checking up.
So from 6/3 has it been extended?
Yes, that is my instruction. That amendment I also take it. That be extended from time to time. That's my instruction was there, Manager. The thing get from charge, that shall be stay operation of order dated such as that, and thereafter was
In 23, which you challenged in that petition, which according to you is pending.
Millard, that order was issued pursuant to this government direction. This is the government.
30th December
Yes, Millard.
2023.
So the language is why matters. So
Yes,
we have to
Millard.
Show us the 30th December order.
That
So,
order,
national ticketing in purpose.
Where is the 30th December order?
I'm giving you.
I think this is a letter of termination, not a order.
that is the letter of termination.
So that is what I really wanted to know.
7/12/2023.
Oh, maybe what notification or not no notification.
Tier 12 order has been stayed by base 108.
Sir, I just want to look at the order of 30th December
108.
108.
And
Yes,
subsequent order is the
just
stay order.
yes.
It is disposed of. That case, 186, it is disposed.
Please, my lord, 1031. Reiterated para 5. As per the advertisement.
Where is the letter of termination?
First termination as so your lordship, page 108.
No, that is not a termination. That is not a termination. That's why I'm asking.
Extended, no termination.
Sir, that's why the extension means there was already a termination. What is this period? Why you extended? What was the initial period?
Below the period, either phase 25 below, clause 4.1. That is the period of engagement.
That I've already read, your lord.
Oh, this is the item spending, then family disposal.
Yes, this one is disposed of.
It has come.
There is no termination order. This annexure 6 period.
Sir, when you entered into an agreement, when the agreement provides that the duration is 3 years, though there is a termination clause, but you'll have to terminate it by giving a notice, 30 days notice, giving an opportunity of hearing, and then terminate if it is unsatisfactory. You can float the tender. I don't dispute to that, but it is always subject to the expiration of the initial period.
whether they have issued any termination letter or not.
That is what we wanted. If the termination is there, clause 8 talks about termination. There must be a termination letter.
And this annex of 6 is not the termination order, that is state.
That is an extension. I do not want that. Why the extension is done? The extension connotes that the initial period expires and then extended.
So,
Here, it may be this instruction letter.
NIA. So,
Now, the date is fixed to 19/5/2020.
So we have got all the orders. My brother is more tech savvy than any other person. He has already downloaded all the orders. Very interesting thing has emerged. The petitioner has placed it very nicely without letting anything know about it. But the fallout of all those things are very interesting. The pending writ petition which is filed, an interim order was passed based upon another writ petition which was pending where the interim order was passed. The court says that since that is pending and there is already an interim order passed in the said proceeding, so interim order is also passed in this proceeding. That proceeding has been withdrawn. Interim order went. his proceeding, which is pending on another end, you did not oppose, and the interim order gets extended automatically on that ground. In his writ petition, the interim order was only because the earlier writ petition is pending filed by another person where the interim order is passed. The same interim order would continue. Will it not be a fresh exercise to be undertaken by the court before extending the interim order? Will you not oppose that there is a subsequent event, the scenario has changed? And interesting, the stay order is passed to a letter dated 30th December 2023, which was not a termination letter, but says that the existing agreement is extended for a period of 3 months. And this order is stayed. That means the extension is stayed. What is the status then? If there is no extension, then what? Extension connotes that the original period expires and it is being extended. But if the extension is stayed, that means what? The period has expired.
So that has been not given effect to. By virtue of the interim order, that was not given effect to.
Sir, what is the letter? Letter is extending. It is not given effect to extension. That means what?
Up to 31st March 2024.
Sir, if the extension is stayed,
that we are allowed to continue.
what is the purpose of the extension?
Extension is you continue. After that, you are terminated. After you have ceased to be a person.
The extension connotes elongation of the period, stretching further the period. That means the period must have expired and it is being prolonged. It is being stretched further. And if this further stretching is stayed, then what is the
period
fulcrum of this?
Here is a case, period is not over. Everywhere and whenever I got the agreement, there was an opportunity of interfering by this court or some other. It was cancelled. I have been before this honorable court for 4 times. If so far your lordship is concerned, your lordship is saying that another the case, that may be, I do not know, that may be relating to the policy. By virtue of that policy,
in your case, you have referred that matter.
The state must have referred because that was
policy referred. And then you say that there is already an interim order passed in that.
I have to examine the document. Unless I examine it, that just withdrawn. I cannot give an opinion. I cannot.
Sir, what are you talking about, sir? Come to page 111 of your writ petition.
Yes, ma'am.
What are you talking?
Mr. Patel was appearing, sir. He knows. The briefing counsel.
He does not. Paragraph 4. You have said that this writ petition is pending.
Analogous matter such as.
Who said?
You petition.
So you are saying I don't know. I have not said.
No. So other case I do have nothing.
Sir, I am talking about the other case. You are talking about the other case. It is you who brought to the notice of the court that this writ petition is pending, interim order is passed there. I think you appeared. So give him a correct instruction, sir. The senior advocate is appearing and saying, is this what to do?
Let him bring that matter and
No, that has to be done.
case, Mr. Patnaik?
This is the tender matter also.
No.
And this is the thing. That was his son was going to the order of termination.
Termination.
So naturally it has gone to level.
Is it petition? That is, I have not to look at 166. All the certificates are satisfactory. Let's look at 166 page on what? 166. Look at how the powers are exercised. 166. Now you can turn to page 16 latest.
This is the case.
Of that, it typically says that tender and they are given tender and cancellation of tender. They also can see page 10 in the first paragraph. And more importantly, when stay order is still existing in his favor here, the authority has no right to invite his tender for the work of that work. Here, this order so far, this interim order passed in that petition is constitutional. Annex 6 is state, that means this extension is state. When the extension is statement.
Question that arises here, the duration of the contract is 3 years. Earlier termination possible, but you have indicated the mechanism or modalities for earlier termination. You have to justify that you have followed that.
But with that effect,
You have not justified that you have followed.
The agreement was on 16th March 2023.
It was 2023,
So
so
3 years lapsed. on
already
February.
lapsed.
It has lapsed.
So it can't be, it has lapsed. 3 years.
Lesson 110 to the
No,
26.
no, no,
110 is the
No.
agreement.
no,
Given effective month.
no.
So you look at,
Look at it as a lapsed in March.
no, that was state and you can look at page 107.
What stayed?
107 is the first order of agreement upon EA who have given effect to. Because of the interim order, the agreement was given, cannot be given, could not be given effect to. That order was stayed, filed by another candidate. Therefore, it could not be given effect to. There was a letter dated 27/9/2023, and it was given effect to from 110.
No, I do not know. The clause simply says that maybe. Clause simply says the period of duration
Yes, sir. 3 years.
from the date of the execution.
Actual that language will not say page 25.
No, that's the agency will be engaged initially for 3 years.
Yes.
And then the last paragraph is paragraph 10 is they put your seal on 16th of March.
16th of March, one agreement was made. It could not be given effect to. It was stayed by dishonorable court.
Maybe may not be given effect to. That is not really extended. It does not really extend the period.
Let's say you look at page 25. Paragraph 4.1. The language couched. The engage, what's it called? 4.1.
Page?
Is 25.
Yes.
Bottom line, 4.1. The engagement shall be for a period of 3 years from the date of actual operation, beginning of service.
Or signing of the contract.
Or from the date of actual operation, beginning of service, then you will can it on, or kind of contract which is latter. The latter is the one day. It is not the earlier. So latter is 1 day now. And admittedly, 26 level is 9 2023 is the letter. Because that was stayed. That agreement was stayed.
When it is a state?
It was stayed by that you will obviously get from the order itself. Page 102. Look, page 101. During the course of the pendency of the present petition, such and such, filed such and such, itself during the notice of this court, that's section that such and such, family court such and such, related such and instruct the collector district development. Considering that the matter was subject before this court, dated such, it was directed that there shall be stay operation of the agreement, dated such and such, executed between the opposite parties petitioner and the authority till the next date. However, the interim order could extended from time to time. Since the present petition is dismissed, the interim order dated such and such and extended stand vacant. All the pending applications stand disposed of, the opposite parties are liberty to work out accordingly. So it was on dated 22nd line. That was the order dated. Perhaps my memory stand correct. I'm sorry, that is 30, yes, 22nd 9, 2023 is the order. Page 57. Shop took 22nd 9, 2009, 23, so I was never allowed to operate because of the interim order passed by lordship order.
There is no observation that you will get an advantage of that period. There is no observation. It simply says that there should be a stay of the operation of the What does it mean? But it does not really correlate. The court would have saved it by an order that the period which has lapsed by virtue of an interim order you can. But the computation will not go.
Be that as it may be law. The advertisement categorically says from the date of actual working or the
But the agreement
that
says,
because is the agreement between the parties and they say only on dissatisfactory work they can terminate it prior to 3 years. No other conditions are available.
So 3 years will reckon from the date of March.
Because it was stayed, but the line is
I'm
clear.
asking, sir, there may be a stay, but after vacating the stay,
Yes.
the court did not say that the period is saved and will not be counted for the purpose of the duration. Then what is the effect?
No, I cannot count. I can go beyond 4.1.
No,
I cannot go beyond 4.1, which says from the date of actual operation. Language is actual operation.
But that is not recorded in the agreement.
But it is an advertisement, my lord.
Whatever, if there is an inconsistency in the tender document and the agreement subsequently entered into, which should prevail, is a subsequent agreement which supersedes.
Subsequent agreement does not say also that it will 3 years. Subsequent agreement says 3
True,
years.
but it does not say how it is to be counted. So the normal rule is that from the date of an execution, it has to be
The
counted.
agreement is state ballot that how can he?
I am asking that there will be a saving clause. There will be a saving clause. It's not like a limitation act where the provision says that if there is any stay order, that period will not be counted for the purpose of the limitation. But this is an agreement that is not saved. That is.
They have given effect from 1/10/2023. Specifically stated 107 page, my lord. You are requested to engage security guards and supervision at DHS with effect from 1/10/2023.
Sir, I understand. I have read it.
Yes.
But there is two concept which is I am really thinking. The concept regarding the duration of a contract is one, and a concept regarding an obligation under the contract is a different. Clause 7 of the agreement says that within 30 days from the date of the signing of an agreement, you have to implement. But within 4 days, it was stayed operation of the agreement was stayed, means you are prevented from providing the services. But so far as the computation of the period of the agreement is concerned, that is the another concept. And the court did not say that I hereby exclude the period of the interim order from the computation of the period of an agreement. Did not say anything. Simply vacated the interim order. And that is why this letter came and say immediately you start operation because you are entitled to a 30 days period. True. That troubles me.
My humble submission.
For the computation of the period is the main issue.
I can advance one proposition. It is implied no explanation is required, Madam.
What?
It is implied that which has been illegally deprived me, that has been taken back.
No, sir. No, sir.
Well, that is why
No,
if something is implied, no explanation is required.
No,
It's implied that the illegal thing which has been done
I am troubled with 3 judgment of the division bench of the Calcutta High Court. That is what troubles me.
These are my case, Madam.
For a purpose of computation, it is one thing. And one of the judgment is of Justice S.B. Sinha. No, I don't think so. We are directing this matter to be listed along with this, but we are keeping this matter next week fast. You'll have to come, and you come ready with that.
It's my limited case and axiom, that's can extend the case. I think it is implied.
The only point it was in, sorry.
64.
Have you seen that corrected?
Corrected, Madam.
You just go through. The corrected one, yes, you just go through. Yes, next.
Item number 5.
5 is also similar. Extension of the
You are.
You had last week, your case.
Calcutta case.
You corrected it?
Similar judgment have you passed?
Corrected.
Last paragraph. This way is
Item number, let me know to correction.
Please give a corrected copy. Yes.
Item number 6.
Point of the security request. So I was the successful bidder.
One process has already been initiated for refund methods. Because recently made an application, process has already started, methods.
Started, then you have to pay.
Yes, good.
Few weeks.
It will, because it's an old matter, it will go to the collector, then to the government, then auditor general. Well, it's at least 4 weeks time will be granted.
With the interest balance. It's been pending since 2020.
But it's the
I made a
application was made
representation
to
and I make sure.
2026.
Whatever. You have. This will give you the one. 8 weeks.
No, but this application for refund was only made in 2020.
No, madam. No, madam. Next to 2, madam.
Or after the audit observation.
71, madam. Page 71. I made an application. Fourth, 2021, madam.
It's the specific
So from that date.
When specific instructions are received, Malus, they have not received any letter, Malus.
That letter, what we have written.
Yes, madam.
Page 71.
Withdraw of my security money.
I do not know what is. I can only read through the Jashita Janeshu, completed withdrawal of the security money,
Yes, madam.
and only I can see 4/3/2021 date.
Page 72, madam. The next
I
page.
can't read the content on.
Yes, madam. The next page also I have read. Next page, my love. They have received 72 annex 3 months. 39 months. They have also received. 30 was from making representation.
Also specific instruction regarding this only, Malus. They mentioned that they have not received it. When they received it in 2026, 18/3/2026, the process has already begun, Malus, for refund, Malus.
What is the signature at the left hand side?
Malus, I specifically asked for this, Malus.
C is also. For this, it is 2021. C is there at the.
Malus specifically asked for that.
We are verbal. When there is a. Disparity of verbal and the document, individual should prevail. So it is a documentary. How the seal came, you can't dispute it. Receiving is there. Somebody has put the signature,
I've seen mine.
same signature.
Seal at the top,
Seal at the top at page 72.
that is for office of trust.
Yes, Malus, I have specifically called for that.
So what, they may say they are bold enough. See. Thus.
Item number 7.
Item number 7, I have a small request, but if the mining officer is on leave due to his daughter's wedding, it may come up on 19th, I'll get the instructions.
This will proceed, Lord, see, because in the meantime, Lord, I was at one.
The agreement is not executed.
That that will be recorded, Lord.
A responsible member of the bar is saying that it is not executed. She will see that it is.
But habit of the government, Lord, on the relevant, they will not there. He will not there. Another person will come and I have not given that statement.
And you ensure if it is not executed.
I just want to let's say one sentence. Though I'm appealing for the beneficiary and 56 lakhs have been deposited by land. 56 lakhs agreement not executed. So I'm not standing in the because you're also fixing banking for disposal. My money is lying there in the land.
Item number 8.
This will agreed by the demand at Annex 4, page 44. The Lordship agreed. Primarily, the two major points on principle of natural justice that we're challenging. They have relied on two documents which have never been served or never seen.
They say that it has been given to you, notice was given on the personal hearing.
I absolutely agree with it.
So
I'll take your lordships to that notebook.
why you say no natural justice is followed?
I'll say, if your lordship sees Annex 4, may I invite your lordship to the first paragraph itself, which says, whereas an audit objection was raised regarding a revenue deficit. My lord has it. So, my lord, my first point is, this particular audit objection was never given to us. Now, my lord, can now come to the second paragraph. Second paragraph, it says, whereas the Directorate of Mines and...
You could have, when the notice was issued for a personal hearing to you, but you could have asked for those documents. You could have gone there and say that these documents are not being given. You have not done so.
My lord, if I may...
So in that event, you can't say that there was a violation of the...
My lord, I'll just reply. My lord, on the question of audit, your lordships are correct. I appeared in the personal.
So why you did not ask for that?
My lord, may I only say, this audit objection, I must fairly submit before this court that when the personal appearance opportunity was provided to me, I did not raise the audit objection issue. I fairly say that. However, my humble submission is audit objection is a responsibility of theirs to hand it over to me. Even if I forget to ask, my lord, I've got judgments, my lord, I'll take a lordship.
Whatever is there.
Now, my lord, may kindly, apart from the audit objection, my lord, may kindly come to page number 45. Second paragraph at page 45. Page 45, my lord, the operational portion, second paragraph. Whereas the competent authority has examined the lessee submission in light of Rule 40 of the MC rules and the specific directives from the Director of Mines. We have never received such directives, but we don't know what directives. Under what directives have they come to this conclusion? That has never been given, well.
What is your stand?
Before that, if I may slightly say, what I intend to ask your lordship is, I have filed an IA. I am ready and willing to deposit the entire amount.
Then
Subject to that is what I wanted to say before, my lord. Let them file accountable.
The instant repetition.
That is 14.
14.
Sorry.
Can't be a 14.
28.
I was really surprised.
28.
So here, may permitted to place this matter, Lordship. Lordship, so I
There
am
is a show cause notice dated
In-
24.
Lordship, show cause I am charging the part of the Lordship. In fact, the show cause is not under challenge. Yeah,
What are we
Lordship.
talking about your first prayer?
Yes, Lordship, but Lordship kindly see the tenor of this, the Lordship show cause. Yes, except jurisdiction,
What will revoke the interim suspension?
suspension, Lordship. There is no provision under law, Lordship rules for interim suspension. Rather, law speaks otherwise, Lordship. He has to give me a reasonable opportunity hearing. As per Lordship can state, Lordship kindly come to Rule 33. 15. The two provision will suffice, Lordship. Section Rule 33, sub-rule 15 and 16.
Which one?
Lordship, kindly come to Rule 33, sub-rule 15, Lordship.
Of
Lordship, also Odisha Minor Mineral Consents Rule 16, Lordship.
30?
33, Rule 33, sub-rule 15 and 16. These two sub-rules are important, Lordship. Let's see what it.
Correct accounts of the minerals other than the dispatch. I will click on inspection 15 and 16.
15 and 16, Lordship. May I read, Lordship? The leases shall keep correct accounts of minor minerals other than specified minor minerals, correct and dispatched and
60 days.
Rightful, Lordship. So, Lordship kindly see his so much notice on 24, Lordship, on 24, he has visited the site and Lordship picks up some point, Lordship, defect, Lordship, and straight away passes the interim suspension. It's unknown to law, Lordship. They don't have power, Lordship, to may give me extension because it's not available under the law. How can a Lordship at a suspension order without any power? I have verified the entire rules, Lordship, no such power available under the law for an interim suspension by the mining officer.
No. What is the meaning of the word prevent the wasteful extraction of a mineral?
Lordship. Sorry,
What
Lordship.
is the meaning of that?
Lordship, rule 16, Lordship.
Yes, sub-rule 16.
16. The lessee shall offer reasonable facilities for inspection of the quarries, Lordship, accounts and records pertaining in quarrying operation. The competent authority
To the
director,
competent authority.
Lordship, now the mining officer, Lordship, competent authority.
That's whatever. To the competent authority.
Lordship, to the competent authority
No.
and director or any other officer authorized by any of them, and such officer may issue directions to prevent wasteful extractions. If
This is
Lordship,
what I am saying.
Lordship,
What is the meaning of the word?
wasteful means for us, Lordship, they are saying unauthorized.
Extraction of minerals.
Let's out if Lordship they are lifting from outside, Lordship, or Lordship any illegal extraction, Lordship, that is for us wasteful.
Wasteful. It is
Wasteful,
not illegal. Wasteful. I just wanted to know what is the
Wasteful extraction of minerals.
prevent things what? Prevent the
Lordship,
waste.
misuse, Lordship, for us misuse of Lordship that to prevent wasteful extraction of minerals and
This is
claims.
what only sentence.
Lordship,
Only what's the expression.
wasteful extraction of
Other you are correct.
Lordship. But here no such allegation for wasteful extractions, Lordship. Can you see come to the show cause notice? That is, Lordship, appears at page 43. Page 42,
Is
Lordship.
there any provision relating to suspension of the query
No,
or
no, Lordship.
termination of a
In this interim suspension, nowhere available.
permanent suspension?
No, Lordship. It can be cancelled.
Where is the other side?
Stated, Lordship.
Can you show me any provision regarding the suspension?
Suspension also, the suspension is not there. But the fact is that only allegation is there for 7 days time has been
I am
granted to him
asking
to
you,
show cause.
sir, I think there is a very fundamental principle.
Yes.
I think is the first principle. It says that an individual can do anything unless prohibited by law.
Yes.
But an authority cannot do anything unless conferred by law.
True, that's it.
Then that's a very fundamental first principle. To show me the conferment of power to do a thing. If there is a conferment of power, can you act as per your own whims? Without
See the
authority
so-called
under the law.
notice. So the so-called notice itself.
Show cause is no doubt. You
Yes.
can issue a show cause asking, but suspension when you do it, I'm asking, where is the conferment of power?
That with regard to that part, I will give my reply. No, after instruction with regard to that, I will give my reply. But
Then
fact,
who
fact,
will compensate for the
no, he is
cost?
not operating. He is not operating. Fact is that he is not operating at all.
But
He is not operating. He says, I am not
if
able
it's
to
not
operate
operating,
because
then why suspend the querying operation?
because that
That
part
is
I will-
what is not a really
But-
mutually destructive statement.
He is neither operating nor
Then why suspend the
nor
operation?
complying the instruction.
That is a different issue. He is not complying, I can understand. That's why I asked this question. Prevent the wasteful extraction.
So,
But
if they solve
suspension of the query operation.
short date they will given, I will satisfy about. To solve the process, fix of a short date, I will satisfy. Now, question is not operating at all. And he is saying that he is not being permitted by.
Maybe.
And Lordship may say, let him comply and operate. There is no objection.
There is a.
And he has already submitted.
Within 60 days, permit him to.
Yes, granted some
fulfill all
time
the
to comply,
conditions.
yes.
No.
I have no objection to lifting the suspension, provided he complies.
Have you given,
Reply he has given already.
already given?
Already given, that is annexure.
With compliance, Lordship.
If it is complied to, they have nothing to lift this suspension or anything. So, next annexure first, page 45, annexure 9.
As an intermediary, you are prejudice to the further action. You are directed, debarred and suspended.
That suspension in effect.
Debarred under what provision? I do not know. What is the language?
Exactly, that's what.
Department again goes back that tender matter.
With regard to the
Civil death.
I am not on
Consequences and.
I am not on that one, not because I have to take instruction with regard to that.
No,
But
no.
option with regard to his operation,
We are staying this portion of the order.
it's not necessary. You can
No,
dispose
sir.
of the matter saying that the so-called
No, sir.
is be considered with
No,
seven.
sir. This kind of a privilege cannot be given if there is a apparent illegality on the person.
Suspension will be
I
lifted.
asked you a very simple question.
Two.
Show us the power where you can debar and suspend the query
No, you.
under the act. Show us the provision. No doubt. We are with you.
I'm saying that the lordship.
No provision. If no provision,
Was that provision, you will also quash the suspension and at the same time also direct him to comply the provisions of law.
the challenges make you then we will pause that portion here and now. And we'll say the rest of the portion, you decide the show cause. I am the last person to say the interim order to continue and then decide the matter. Interim order cannot survive beyond the disposal of the litigation. So that's my understanding. I do not know the understanding of the others, but that's my answer. If you want, we can cautiously.
Fix up a date and pass it.
When?
Give me 1 month time.
Second week of July.
Yes, ma'am. Item number 10.
So wasteful excessive mining lordship, that is enter to the environmental meaning wasteful.
Yes, it is. You literally get annexed at 15. Page 77. Where my application, page 77, annex of 13. 1 year.
Yes.
But I am one prospecting license holder under 77.
No, please 77 the.
So,
Brief. Page
77.
So 13.
Annex of 13, page 77. Here the directorate of mines. Also times the subject. Mining application number 14, Padapati dated 10th of February 2010.
Decorative stone.
Yes, ma'am.
Area of this.
Yes, ma'am. Now, my application of 2010 was rejected. Lords may kindly see the next reference in inviting reference to the letter cited above on the caption subject. This is to implement that
The auction rules have come. Meantime, the auction rules have come.
yes, but my request, my
Submission may be prior to the auction regime.
yes,
But now the auction regime has come in 2015.
16.
So, whatever, 16 or 15. But the
The rule 4, the rule
what
they
it
have
says.
yes, this rule they have quoted here in the interview letter. They have quoted rule 413A of the OMC rule 2016, which clearly mandates that the right to obtain a mining lease, including the pending cases, shall lapse upon.
No, that is a wrong impression they have given, the wrong provision. But I am talking about that after this auction regime was introduced,
Yes.
what is the fate of those earlier applications?
Because those application which is already there prior to the
Can it be, can it
Yes.
survive after this rule came into place?
Lord, and therefore I'm putting the relevant provision under the new rules. OMC rule 2016. Lords may kindly see rule 15, sub rule 7.
What it says.
The chapter is grant of mining lease for specified minor minerals. And under rule 15, my lord.
This is a specified minor mineral?
Yes,
This is decorative stone?
my lord. Yes, my lord, decorative.
Specified minor mineral under the schedule?
Yes, my lord. Because under the annex of 1,
Then can we
your lords may kindly see rule 15.
auction rules?
Rule 15, sub rule 7.
Auction rules. Auction rules.
Yes, OMC rule 2016. Yes, mineral concession rules. Minor mineral concession rules 2016. Lord, rule sub rule 7.
Yeah.
It starts from notwithstanding anything contained in this rule. A, where before the commencement of these rules,
Which one? 17.
15, rule 15, sub rule 7. It starts from notwithstanding anything contained in this rule. A, where before the commencement of these rules, a prospecting license has been granted in respect of any land or any specified minor mineral, the holder of the prospecting license shall have a right for obtaining a mining lease in respect of that minor mineral in that land, if the government is satisfied that the licensee one has undertaken prospecting operations to establish the existence of mineral contents in such land in accordance with just such parameters as was prescribed by the government, who has not committed any breach of the terms and conditions of the prospecting license. 3, has not become ineligible under the provisions of the rules which were in force before the commencement of these rules. 4, has not failed to apply for grant of mining lease within a period of 3 months after expiry of the prospecting license. So my application which was there under the 2004 rules. has been said under these rules as well.
66.
Okay.
Rule 66.
Rule 66. Rule 66. Of this rule.
Yes, 66 2.
Right. And rule number 67. Rule 67.
Transitory.
Transitory major mineral pathology.
66 2.
66 2. Not finding anything to the contrary contain these rules. The applicants of mineral concessions in respect of such of the specified mineral minerals, which were major minerals on the date of coming to force of the mines and minerals. Remember,
Context.
in respect of major minerals on the
This one is
specified mineral. Rather, my case comes under Rule 67. In this case, notwithstanding anything contrary to the contrary content in these rules, the applicants who have been granted prospecting license or mining lease or quarry lease prior to the commencement of these rules shall be entitled to execute the deed of license or as the case may be lease within the period specified in the grant or within such further period as may be allowed by the controlling authority. In my case, under answer 1, I have got the prospective license in the year 2008. That license was for a period of 2 years. As per the deed in 2004 rules, I applied for the mining lease, which was accepted in the year 2010. From 2010 till 2016, 26, they sat over the application and continued with there are many multiple directions passed to the different authorities, such as the revenue authority like Tahsildar and the forest authorities, to give their NOC. The forest officials have given their NOC, revenue officials have also given their NOC. So the very ground on which my application is rejected is not HARISH according to the law. Can you dictate?
abundant caution, mention item 6 in the weekly daily list that my lord has some urgent reliefs are required. And just saying sometime before writing in case it doesn't feel good, your lordship.
We have taken which matter?
Supplemental list, for
How many matters?
4 matters.
Huh?
4 matters, sir.
No, so we'll be coming and disposing of, we will go and which 4 matters are left.
No supplemental list, ma'am. Then weekly list will call.
Okay, 4 matters.
6 of the weekly decisions.
Dispose of that.
Hmm. 186, my lords.
Let's have a preliminary objection here. May I just state my, because it will help my learned friend, whether you would like to proceed or not.
Objection will help him.
Well, admittedly, my lords, here the financial bids have been opened. Financial bids have been opened. He is challenging the rejection of technical bid. But nowhere in his petition, either in the writ petition or even in the application for amendment which has been filed, does he disclose about his financial bid. So, my lords, even assuming that his amendment gets allowed, the adjudication would be an academic matter because one doesn't know what his bids are. There are 3 qualified bids. There are 3 financial bids which are qualified.
Bids, I can disclose my bid, but bids are with the principal. So I need not. Bids are lying with them. I cannot touch the bid.
You know what we have.
I know the gap is 24 crores, 24 point odd crores. I have instructions. I can file an affidavit on that 24 crores. Then the L1, my bid is less by better.
Nowhere in the writ petition or in the amendment application is that stated. Nowhere in the writ petition or in the amendment
I can
application.
file an affidavit on that. The rejection manner is per se perverse. Your lordship may kindly. Page 186, annexure 7. They qualified 3 bidders.
What do you want to amend? What do you want to amend?
I wanted to delete one prayer, one government. I had one contention that I had stated that they have not, the OBCC has not defined the word subcontract in its bid. That was in a hurry, my lord. I have said that I want to delete that. They have actually defined the word contract and subcontract. It's a formal amendment. It's a formal, very formal
He
amendment.
wants to amend his prayer also. That the prayer amendment.
One, I'm challenging this annexure 7. To the extent of only this disqualification. Annexure 7. They have disqualified me, my lords, only on the ground that I don't qualify in the technical bid as per clause 1.2, annexure 2 of the ITB, section 1 of the RFP. That your lordship finds at page 175. This was the page, my lord, I fumbled on the last occasion, my lord. Page 175 is actually the markings, the pattern of the marking that they
Whatever you wanted to challenge this annexure 7.
The annexure 7 is I've added, and my main challenge is to annexure 13, the rejection by the chief engineer of my bid.
But this has to be challenged here.
Yes,
So that is the disqualification. You have to challenge.
That's the amendment.
That is a follow-up action of this.
Man, I have also challenged annexure 13 also.
You have challenged annexure 13.
By way of amendment.
Annexure 13 is a follow-up of annexure 7.
Reasons come in annexure 13. Reasons come in annexure.
You'll have to challenge this.
I have challenged it. The amendment I brought.
By way of an amendment.
Man, I brought the formal amendment. I've just added that.
Where is the application for amendment?
Application is managed IA 9072 of 2026. Is there in your flag D?
Where is the schedule of amendment?
Schedule is
Page 5.
page 5.
5 onwards.
Five onwards.
Prayer is at page 7 if you log.
Page 7.
It's not the amendment, but that is not ground you want to amend.
Man, the ground is, I've given the,
There is a material change in the.
Ground you can take, these are the grounds both of the existing facts in the law. You want to amend the ground.
man,
Then where is the? Your lordship might come to page 7, the prayer.
page 7,
What the prayer they wanted to challenge this annexure 7.
issue approved.
That they have to.
Man,
When they are within the period, there is no limitation.
man,
There is no delay.
24/4/2003. Later on the
So this is an application for amendment of the repetition. Incorporating the additional prayer as well as the grounds in support thereof. So it is further submitted, it is submitted according to the petitioner. Unamended copy has not come.
The IA is already there on record.
Sir, after the amendment, the IA is dependent upon the pleading. Is the main matter. Let the pleading be completed first.
For the time being, I get your point. I get your lordship point for that.
Come on Tuesday.
Item 12.
I'm working down.
No one. Come on. Come on.
Did there was some form of protection in some way? What will happen, the point is very simple, my point is very simple and crisp.
We consider it, if we set aside the order, we'll see the potential way to be opened. If you are L1, everything will be done.
At least subject to result, whatever happens is subject till then. Till then it will be subject to. Otherwise,
There is one sentence I use in the Calcutta High Court which I do not want.
What will happen, Manoj? I bow down to your lordship, Manoj's suggestions. What will happen, Manoj? They'll claim equity. Once they claim equity, Manoj, it's highly
no question of the law. Equity is different.
Once what part has been issued, they'll say
the equity is shown only in a partition suit.
Item 12.
It's coming on Tuesday, Manoj. Tuesday.
That's the deal for these.
Yes, 9 days.
Can I only pay, Manoj? Let it down fresh admissions. Only this much.
Yes,
only this.
Because it just has to come.
Only this.
Yes.
12.
Is the number?
12.
Yes.
Already.
This is the matter which your lordship, the application for additional appeals is already there before your lordship.
There is a condonation application.
No, that is already been disposed.
Item is concerned, but there is a condonation. So item is concerned, there is a condonation. But the last item is not. It has not yet been.
First matter is the lead matter. The second one is more or less studying the same.
But we have to allow first.
Yes.
Otherwise, you can't touch the second matter.
Your lordship has already condoned the deal.
Second matter.
In a survivor.
Second.
Over.
6 days.
6 days. This is an application for condonation of delay. The
Tenth of January 2023. And at page 156, I told to your lordship the last few lines, wherein the matter has been remanded. The Tahsildar Kujan is therefore directed to correct the ROR within 3 months on receipt of the order, only after proper field inquiry and verification of the related documents following due process of law. So it was a reminder. Against this order, Paradip Port Trust came up in a writ petition. Now your lordship may kindly take that writ petition, that order begins at page 159. Your lordship may take page 170. Para 12. Para 12, as per discussion and observations made above, where when it is held that the recording of the case land and a Hal Khata so and Hal block so in the name of Paradip Port Trust is baseless, then at this juncture, the impugned order passed by the Land Reform Commissioner under section 15B for correction of Hal ROR for the case land for the name of Paradip Port Trust in favor of the successors of Sabik recorded tenants, including the petitioner thereof in this writ petition, cannot be held to be erroneous. So he misinterprets the order and he holds that the Commissioner Land Record has directed that the lands are to be recorded in favor of the opposite party number 10, present opposite party number 10. So, in the meantime, what the parties did not point out to the Honorable Single Judge is that in the meantime, the order of the Commissioner Land Records had already worked out. Kindly take additional evidence, IA number 1770, page 9.
One is flat.
1770.
Okay.
Yes.
170, page 9.
Yes.
Please take the order at the bottom of the page, 6/11/24. The case record is taken up today. The miscase is initiated on the strength of the order passed by the learned LRC on 10/1/23, which I had read out to your lordship. Wide RP number so and so, and the order is communicated to this office wide.
One line is missing. What is it there?
As such, the petitioner is allowed, a petitioner is allowed in the favor the vessel that thereafter the operative portion is about 10 lines from the bottom of the page. Sentence beginning as per the said land schedule. As per the said land schedule, no private entity is in possession of the land over plot number 51, Khata number 1 of village Vittargarh. The Honorable High Court, by order dated 28/15, observed that the Paradip Port Trust as well as the Government of Odisha jointly stated that land dispute between them has been resolved in terms of the settlement arrived as per minutes of the meeting dated 31/15, and accordingly, this case 869015 arising out of so and so was disposed of. Further, CS number 205 of 2020 was filed by a private entity in the court of the Civil Judge Senior Division.
So it is that it is in your position.
It's in my possession.
The land acquisition proceeding was initiated, section 6(1) declaration drafts.
And Paradip Port Trust was in possession. Record of rights are in favor of Paradip Port Trust. His application for mutation was rejected. Now, after this, my lords, what happens? Your lordship may kindly come to page 17.
This is the order of the 20.
This is the order dated 6/11/2024.
This was not brought to the
notice of the Honorable Single Judge by any of the parties. Now, my lords, next your lordship may kindly come to page 17. Now, being emboldened by the order of the learned single judge, this is what happens. In the court of subdivision,
that's true. It must get an opportunity to deal with this. These are the documents which are forthcoming here.
I have served advance copies to them.
Correct. So now they are contemplating to get themselves, they are recorded or made an entry in their favor in the record of rights.
That is already over. That, rejected by the.
No, that is there. What is the order has to be implemented.
The order has already carried out.
The court has said that recording of your name or entry in the record of right in your name is business.
No, not in my name.
No, single bench has done.
Yes, sorry, man. Sorry.
Entry in your name is the business.
Yes, man.
And this is what a declaration which is made. And on the basis of a declaration, the right must have emanated into a party to get their name recorded.
Right.
Have they approached the concerned authority to correct the record of rights?
Yes, Bharat. That is exactly what I wanted to bring to you.
I know it, that's why I'm asking. Have they approached?
Yes.
What the authority is doing?
The authority has passed an order which your lordships get at page 25. This is a communication made to the Advocate General.
Yes. What?
submission of compliance in WPC number so and
So
so.
they have already done it.
They have done it.
So now, so far as the entry is concerned, we will definitely consider those aspects. They must get an opportunity to file a counter both to the additional evidence as well as the main resolution.
Additional,
Both. They have a right. So they should file.
yes, ma'am.
We are observing as an interim users that since the recording has already been made, the mutation has been effected, it will always be a subject to the result of the instant appeal and will not create any input right in or a wasted.
Difficulty is, my lords, on the basis of that order, they have attempted to enter upon the property, which has been restrained.
The problem is, I will not part an order of status quo without
Injunction, my lords, I am seeking an injunction.
then I have to say that you are in position.
I have, there are ample materials to show.
But they are saying that they are in position.
No, my lords, it is the finding of the authorities is that they are not in possession and they have been arrested for attempting to enter into possession.
Where is that?
That is all there. That is exactly what I wanted to show to you.
Was-
Kindly take page 17 of that additional affidavit.
Yes. Yes.
In pursuance of DR number so and so, Paradip Model Police Station, keeping in view law and order situation at the premises of prevailing earth movers, that is me, common corridor PPA, Moja so and so, ye, Jagat Singhpur is satisfied that there are sufficient grounds for proceeding under section 163 of the BNSS. This is 144 CRPC, and that immediate prevention is desirable. And the situation, if not checked immediately, may lead to undesirable consequences. Hence, I do hereby prohibit under section 163 of BNSS at the premises of so and so, located in so and so. And whereas the circumstances does not admit of service and the order is directed against the public in general, this order shall remain in force until further
Where
orders.
is the property?
Sorry, Manu.
Where?
Paradip Port area. Now, my lords, over the page, next page, kindly see.
This is FIR is law.
FIR is registered under section 329, 296, 351.
Whatever is there, I am looking at the content of the information report.
Now, if your lordship sees, there also,
Then
where security personnel, so and so, further on 21/4/2026, at about 6:15 p.m.
no, I
Said-
have seen that next we see the written content, then what is the, there is nothing.
Now, my lords,
And you have gone for 144, that's the old one,
no,
63 now.
now, next your lordship sees what he has thereafter done. He has misrepresented before this honorable court at page 23. He has filed a writ petition saying that his mutation application is not being taken up, even though he is conscious of the fact that it has been dismissed, it has been rejected. He makes an application to this honorable court and seeks a time limit for disposal of the miscase. And, my lords, the honorable court, being misled, says that dispose it of within a period of 2 months.
Which has already been disposed of.
Which has already been disposed of. So, but this is the mischief that is being perpetrated day on and day in. And this is the situation which requires, my lord, honorable, there is urgent requirement of an injunction because an industrial activity is sought to be arrested.
Just to add one more strong document is a joint demarcation between the government and Paradip Port. That would be annexure 5, page number, page 44 of the writ appeal.
Okay, sir.
That was held way back in 2008.
Page 54.
Page 44. It begins from 44 and PDF page is 69 and relevant entry is at page number 54. So this So this demarcation happened way back in 2008, and this suit line is included there. So at that time, the private opposite party never objected to this, and this dispute ultimately was resolved in terms of the orders of the High Court. So far as possession is concerned, it is very much with Paradip Port, and we have leased it out to the applicant. So possession, there is no dispute that the private opposite party is not in possession. So in terms of that, your lordship may protect the list till my lord they rest.
Your lordship may kindly see the prohibited order. This is not my plot. Plot number is something different. Hata number is 1, but it is not. My plot is, yes, Hata number 1 there. Prohibited order against the plot number 5.
Hata number 1.
That is the recorded in the favor of Paradip Port Trust. Recorded tenant was the Paradip Port Trust in the.
Here, Hata number 1 is prepared for the government land only.
By the Survey Settlement Authority. That Khatians number 1 has been prepared by the Survey Settlement.
I have come from another state. I am asking. There in the Khatian number 1 means whatever the land belongs to the government is always recorded in Khatian number 1. It is a one record which maintains all the government land.
But here may not get.
That's why I am asking whether Khatian 1.
No, my lord, here may not get.
The government.
The Khatians has been prepared in the name of the individuals.
I understand. My judgment is there that Khatian, what does it mean? Khatian means a person may hold 15 properties, but he will be, all properties will be recorded in one Khatian.
Yes.
It is a one Khatian for the different properties belonging to the same person.
Same person. Here also this.
No, that's why I am saying, aware of that.
But the fact remains, my lord, that we are in possession and we are also in possession.
How you assert?
Because yes, our assets, my lord. While they have filed these.
Do one thing. I am appointing a special officer. Let us go there and find out.
Yes. Yes, my lord.
In fact, the collector of the district had to go and camp there to ensure that the pillars that they had forcibly affixed were removed. The collector had to go and camp at
They have violated the order, my lord, of this annual
Has been removed. So there is no difficulty. The government asserts the position. Who is there today? Can we appoint a special officer?
Yeah, Lord.
Yes,
I have known this.
Yes.
Also, instead of
Sunday. Because
Till that
read Kishore Khetan's case.
My lords, till that, my lords, I would pray.
2006, volume 4 cases.
My lords,
Read the words, the language used in that.
I leave it to you.
My lords, I would in that circumstances pray that in these circumstances, on the basis of the materials before your lordships may rescue him from
my lord in trade submitted. We have not been hard. We do not know about this case.
Sir, there are two concepts.
Your lordship may kindly see this.
Consider what troubles or what is going on in my mind. First thing is, though the entry in the record of right does not create any title nor extinguish them. It has a presumptive value of possession in favor of a person whose name it is recorded. I think this is like the situation. Once a presumptive value comes, let us see who is actual. In Kishore Khetan, the Supreme Court has duplicated the order of status quo to be passed by the court in relation to a matter where the dispute as to the position is involved. The Supreme Court says that before passing an order of status quo, the court must arrive at its decision who is in possession thereof, and thereafter will pass an order for status quo. Please find out that judgment.
May I answer? My lord, may I answer this, my lords? Here is a case where this person had filed a suit for injunction against me. That suit was, the claim in that suit was rejected. Against that, he preferred an appeal.
On what ground?
Without
Part by law or not disclosed?
any cause of action.
Consider the case.
Without any cause of action.
Question.
A and D both.
Question is of a position. Had it been a case that he has no position and no prayer for recovery is sought, simplicity or declaration prayer is there, Section 34 comes into play, I can understand that he is out of court. But once it is disputed, then we have to ascertain, we are appointing.
May I suggest one thing else? In view of this urgency, your lordship will take care of that urgency and not. So far as what falls to my lordship regarding
will go within this weekend. Let him go.
I think that
My lord, Paradeep is not far. He can go today itself. Let him go. Let him go.
Meanwhile,
Let him
we have
go today.
some problems there. That's the reason I'm.
Because it's a volatile situation, my lord. The entire villages are.
They have violated the order of status quo while it is pending. They have violated.
Sorry, the villagers. The villagers, they are coming in a group because they want to grab this land. And that is exactly what has been happening. Your lordship sees the chicanery that has been exercised through and through.
Because of that urgency, your lordship may appoint someone, but keep the time gap less.
No, we can keep this matter on the next Tuesday.
Mind.
We'll go into that. No problem.
Yes, no.
I think that.
My lords, the chief secretary's report is also on board, my lords. The chief, my learned friend was referring to a report of the Tehsildar.
Yes.
It is an order that is passed in circumstances which are favored and the premises and values clearly justify finding that the status quo has been altered or one of the property interest of justice of the matter that is anything restored by the
Let us know when the position is of dispute.
before ordering and mandatory events are refusing, the court has first considered whether the plaintiff has proved that he was in possession on the date of sheet and on the date of order, and he had been dispossessed the next day.
Well, here there is no dispute with regard to possession. The state says that the possession is with Paradeep Port Trust. Paradeep Port Trust says that the possession is with it. Here, my lords, a single person comes forward and says that no, I have been in possession on the basis of the record of rights of 1931. And that too, there is no connection between the recorded owner and him.
You are facing one judicial judgment against you.
Correct, my lords, but that was once.
Unless that finding, the judicial order is set aside, at least it has a binding effect. Please consider this aspect first. We are saying that all these things are there will not do.
My lords,
have you got that SCC 2006? What? We have got an SCR here.
2006, 3 SCC, 312.
212.
Yes.
Okay. Yeah, they gave me this.
Lordship bonds, I have it on my.
I know, I have read it. For you people, I just wanted when you say that you give us.
No, all that we want.
As on today, that is what I was saying.
It's about 177 acres of land. So we don't want any law and order situations further. That's why I wanted to apprise your lordship.
And this is a case where, my lords, records show that during pendency of the case, when the appeal was on board, all these things are happening. or the state council.
State council.
State councils are also there. Whenever your lordship may,
Only anybody.
any one of them.
Any one of the.
He wanted a strong-headed person.
Everybody is strong. Mr. Swai is there.
We am around civil law, DN.
He is also senior advocate.
Senior now don't have no.
I'm sorry. Mr. Pal is here.
Mr. Pal.
Mr. Abhijit.
Yes.
Permission here.
Can you spare time? In a weekend.
Then there's a family function.
So here's the family, his brother's daughter is getting engaged today. So we are all invited.
Engagement.
Engaged, so it's today.
Yes, so can you go and begin? It will be over for by all. This function.
Today function is already over. We are also missing the lunch.
I'm stuck here.
Why?
Item 14, so.
No. Hurry. Share something. Is remuneration. He's nodding head now. He will involve.
The fresh admission कैसे? Yes. The same.
So this, what is this matter? This is the interfere. And challenging the about the no study as when I living the matter is that we are honorable single judge without taking into consideration of my submission and also the citations I have submitted, pass the order stating that since I have participated in the interview, I have been established to challenge that thing.
So is this fact wrong
Yes, Lord.
that you never participated?
No, I have participated, but I am not challenging the advertisement. Lord. But the works which has been done by the opposite party not clear for beyond the advertisement, I am challenging that. Lord. They cannot change the norms or terms during the tender period, and there's the process is going on. Lord.
Where is the judgment of this?
Madam?
Where is the impugned order?
NSF 5 Lord explains. NSF 5, page 194. And the operative person here 203 mirror. That is when the selected SSG that is operated part of 6 has been operating and managing the SC medical since 28/11/2025 successfully without any complaint. And when the operation and management work of opposite party number 6 SSG to the SC medical Ahar Kendra is only for 1 year, then this juncture any interference with this process selection the petition filed with the petition SSG shall ultimately affect the smooth distribution of Ahar instead of medical.
Yes, would you like to file your action?
I'll file a reply. I'll file a reply.
We have filed in the trial court?
Yes, the court, the learner.
I mean the single wage.
Yes, I have already filed.
Yeah, filed.
Yes, please.
Is it annexed here? Counter
Yes, I have an issue. But that is annexed.
Show me your writ petition, sir.
My petition is annexed 1 series.
Page
15. Page 15. That is 15 to 89.
Just yes.
Where is the criteria which you say awarding of marks? Show us where is the awarding of marks? Myself.
Page 45 पे kindly see. This is the 45 of the advertisement. Where they have stated the marks will be given to the SSG groups. Page 45.
So this, and where is the criteria?
And this
Other criteria.
criteria and parameters.
What would be the effect of a marks? Show me. What is the purpose of this marks?
Page 42. This is the parameter and the criteria. Serial number 10, sir.
Where is the role of the selection committee? Which page?
Well, that committee,
Which?
it was not known to the public, but it was given.
Whatever you participated yourself, not known to the public cannot be taken now. Tell us what is the role of the selection committee?
The selection committee, they
Yes, tell me, sir. You are the
144 page.
one.
Page 144 of the bill. Page 144, my lords will see proceeding of the meeting for selection of MSGs for O&M of Ahar Kendra.
This is prior to the notice of the tender.
This is after.
No.
That's a council resolution, my lords. That has not been translated. That is at page 139.
I have given the page translated copy of page 139. Translated copy. There,
Translated copy I have there.
yes, Vinod. And in that
Just sorry. This is prior to floating of the tender.
yes, Vinod.
No, this is a proposal for Reliance and Social Justice Standing Committee.
Yes.
I am asking about the selecting committee.
There is nothing, Miller.
Nothing means-
That was the proposal committee. They have given the proposal, and in that proposal they have stated the new SHG groups will be given the preference instead of the old the SHG groups, and that will be reflected in the advertisement below. It is 6/9/2025. Thereafter 14/10 to
I know that. Counter by how many?
10 working days.
They joined us 1 week after.
Hello.
That is the hearing immediately the first day of the second.
Item 14.
As per the judgment of as per the order of the honorable signature, I was giving the distribution of the center.
Yeah, whatever.
And manner there is
Yes.
but that
Item
has
14.
technical consideration.
See, we are not making any observation at this. This is not.
Item 14.
The case where your lordship in the last, it was listed day before yesterday. The lordship said that the judicial order and that in case
Judicial order from.
well, they were the petitions for the parliament.
How can the judicial order be challenged? How can it be challenged?
Because his judgment of your lordship's.
Absolutely, Sudhadev Raj says it can be done 226, 227.
Yes.
Radhesham
says
aside the
227. What has happened here? What has happened?
226,
Nobody has.
227.
Yes. What has happened is on the 10th of March, your lordship's judgment came. This judgment on the 11th of March. So we're not
I
aware.
do not know, but that is what a judgment is.
My lord, if I may only state my predicament, my lord, just before.
No predicament.
No, my lord, can you hear me out? I'm not trying
It
to.
has to be registered as a CMP.
So straight away, we have satisfied the order.
I can't stand on the way.
They were right.
I don't stand on the way, my lord. I only say something else, but in that similar matter, which my learned senior is giving the judgment of, which is similar, there, my lord, the arbitration was already over. I'm just bringing to your lordship notice that here, my arbitration or our arbitration is still halted because they came in section 14 and 15. So it can be taken up.
When it goes out and the order is set aside, what remains? You are the appellant here.
No, my lord.
I am here.
You are the appellant.
If I may only state it.
So your writ petition was allowed, his writ petition was.
No, his writ petition was dismissed.
So it has to be CMP and again heard.
My lord, may kindly just hear me.
Why you are not an aggrieved person.
I am an aggrieved person.
Nothing, his writ petition is dismissed. What more? Problem is that you are not an appellant. You are not a person aggrieved. You cannot seek any further order in your favor when his appeal is
Completely bowed down. If your lordship gives me.
So you wanted that has been halted. You direct the disposal of the arbitral proceeding at the earliest. We are not going to pass it.
May I lastly? Your lordships, in the order that your lordships are now passing, I'm only on the order that my learned.
You are simply dismissing the appeal. Simply. What wrong in terms of
If they're dismissing the writ appeal, I will.
And then say that since 227 does not lie, 227 is a ward. 227, that right is there.
That is where I'm coming to. My lord may see the last portion of the order. Your lordships has mentioned it that we expect and hope that the moment the matter is listed before the appropriate bench having the requisite roster, precedence shall be given to the instant matter in securing the disposal. That is what I'm only praying, my lord. If
Same
that,
order will pass.
exactly.
Same order.
That is what that is exactly what I was trying to say. Because their rate petition has been dismissed.
What is all this granting the liberty to
Your lordship may convert if it is because that period of limitation and all those things.
227 limitation? Since when?
It arise they may.
I'm asking you
Yes,
since when?
Conversion is
226 limitation has not
better.
No.
Your lordship
Person that should have been converted.
My lord.
Because we convert this.
No, lordship is converted. That's why I'm saying. Otherwise, your lordship may permit me, I will convert.
My lord, in fact, that may not be necessary because my lord may see your lordship para 18. Your lordship had written that order. Your lordship has said that petition is revived.
Item 15, sir.
Wait.
The present issue before your lordships is very, very small.
Small?
Yes.
Maybe apprehensive.
No, we are there to relieve the lordship.
Well, there is, my lord, a bank guarantee which is furnished in terms of a, my lord, mining development agreement. Well, there is provision for enhancement of the, my lord, quantum of the bank guarantee every 5 years. The old bank guarantee, my lord, has now been replaced with a new bank guarantee. The old bank guarantee was for about 154 crores. We have now furnished a new bank guarantee of 258 crores. My lord, we want the old bank guarantee to be released. Now, my lord, the old bank guarantee was furnished by a company which is no longer in existence because, my lord, that company has merged with the repetitioner company.
By virtue of an NCLT order.
Yes. And, my lord, that, my lord, company is now dissolved without winding up. So, my lord, its existence is no longer there. And, my lord, my learned friends are not entitled to, my lord, two bank guarantees. They are entitled to the enhanced bank guarantee which I have already furnished. My lord, I only want refund of my, my lord, earlier bank guarantee. Or return of mine. I'm sorry.
Who will refund?
No, my lord, return. Return of the bank.
Return, who will return?
Well, the state will return.
That is,
Now in the meantime, what has happened? The company which has merged, that the company that is name is Nippon Steel India Limited. Now it is renamed as Steel India Private Limited. Now the third one is a stranger to us. We have no connection with the third one, the Mittal Nippon Steel India Private Limited. So the third one we cannot keep the bank guarantee of that.
I could not
Now there are three companies. Now three companies are now.
No.
Initially,
Please, let me answer.
yes.
Who initially gave you a bank guarantee?
That
Give the
Arsenal
name.
Mittal is the Arsenal Mittal India Private Limited that has given.
Initially. That is 100 and something crore.
Yes.
154 crores.
Yes.
That is the Arsenal Mittal Nippon India Limited.
No, Arsenal Mittal
Arsenal
India Private.
Mittal India Private Limited.
AMIPL.
Arsenal
Mittal India Private Limited.
I prepared a short
Nippon
note.
Steel was not there.
No.
Okay. So
I have noted.
no,
I have noted
then-
all these things short. That will be clear. Everything will be clear. Everything will be clear.
How the authorities, they understood the nuances of the law. Let me understand.
Yes.
Yes. I could not make a head and tail from this instruction. I could not.
Look, may I
Please,
clarify?
enlighten me on this. I could not make out any head and tail.
I'm making.
Well, I will kindly allow me just.
Let me explain.
No, you
I will
you
explain.
explain in a.
Well, I'll
I will
explain.
Initially,
Bank guarantee given by AMIPL, ArcelorMittal India Private Limited.
correct.
ArcelorMittal Private Limited thereafter gets merged with ArcelorMittal Nippon Steel India, AMNS.
Okay. By virtue of a scheme of merger being approved.
Approved by board, by the NCLT.
NCLT.
Yes.
Okay. So
Now, my lord, the new bank guarantee is now, my lord, given by, my lord, AMNS, that's ArcelorMittal Nippon Steel, the merged entity.
India Private.
No, another company.
No, I tell you, lord. My lord, now, my lord, this company which had given the bank guarantee, my lord, later, my lord, applies for a change in name and, my lord, its name is changed.
name is changed under the Companies Act.
Yes. Under the Companies Act.
By
my
the
lord.
registrar of companies or what?
Yes, my lord. There is a, my lord, order certificate of incorporation.
Section 25.
Yes.
Of the Companies Act.
Yes.
25.
Yes, my lord. My lord, today, my lord,
Am I correct or wrong?
my lord, this is now, my lord.
Change of name.
It's only person to private.
230 to 32 of company.
Well, now, my lord, the sections have changed because the 2013 Act is coming to it.
Talking about 56.
Yes. That's it. Now, my lord, there is a, my lord, change of name and the new certificate of incorporation is granted consequent on change in name.
Okay.
Well, that is the only confusion. There is no other
Change
confusion.
of name does not mean.
No. Now, my lord, my learned friends are admittedly under the, my lord, mining
He
development
has
agreement.
raised the stamp duty concept. He has raised registration.
Well, that is, my lord, matter in the main writ petition. We'll answer that question. Well, lord, your lordships are given directions for filing affidavits. Affidavit not yet filed by the state. Well, lord, whenever they want to argue that matter, I'm ready to argue that matter. Your lordships have given certain interim orders so that the mine can function in the meantime. Well, it is functioning. We are prepared to address your lordship on that whenever your lordships find it convenient to take up issue. Now, my lord, we are only concerned with this question because in the meantime, my lord, during the vacations, my lord, the period of this bank guarantee will lapse. And my lord, today, my lord, we apprehend that they will then, my lord, proceed to encash the bank guarantee, although they are not entitled to, my lord, two bank guarantees. Under the agreement, they are entitled to an enhanced bank guarantee after 5 years, which we have
Now,
furnished.
the lease is granted in whose name?
Well, the lease was originally granted in favor of,
Ultimately, change
Well,
and all.
lease was granted in favor of AMIPL, ArcelorMittal India Private Limited. Well, consequent to the merger, well, this lease has, well, now come to AMNS, that's Mittal Steel, Nippon
They
Steel.
recognized it.
Well, they have said we recognize it subject to payment of further stamp duty. That is the issue.
In fact, one second. That they have not said that. I'm so sorry. I'm sorry. Just to support. Government passed. I'm supporting. I'm for the also. Both of us are agreeing with Mr. Sir. Now just see one page, page 196. Government has allowed change of name and directed them to enter my new name in the concerned lead document. Government has passed this order.
No, Mr. So far as the change of name is concerned, I do not have
Any dispute
in
about
mind.
Correct me.
Absolutely. Change of name, I know what is the effect. But once it comes as a merger, now there appears to be something.
Yes.
There appears to be something which should be gone into. Mr. Saha knows better.
Well, your lordship judgment is also there sitting in the Calcutta High Court. Well, we are aware of that. But well, here there
So
are
that is what I was just thinking about it. That if it is a sheer change of name, no confusion.
No, it's not. It's a. I see
But
page
it
1.
appears that there is a merger. Now, the transferee company.
Yes.
Merger
The transferee company is
Nippon Steel. Transferring company is given a fresh bank guarantee.
fresh bank guarantee.
Yes.
Now it's a question of a bank guarantee only, not a question of anything.
Well, that is the subject of the main petition. In the IA, we are only concerned with the return of the earlier bank guarantee, which has now ceased to remain effective because of the provision of the contract itself. Well, the MDTA, which contains the provision for performance security.
There cannot be a two bank guarantee.
Yeah.
If I understood from their stand, the state government has agreed to transfer the lease in the name of the transferee company.
Yes.
So why did he
The question is the payment of a stamp duty is concerned.
Yes.
Right?
Yes.
So the question of stamp duty we will consider.
Yes.
Now the situation is that once the government has taken a conscious decision to transfer and the order of merger has really taken effect.
Yes.
Then there is no existence of a transferor company. It dies naturally.
Yes.
Naturally. How can you invoke anything or given by a dead person?
Correct.
There will be a problem. So it's better when they have given a better bank guarantee which secures your interest.
You also pass that object
In
from the
that event, you return the earlier bank guarantee of the transferor company and will record that it is been substituted by a transferring company. Question of stamp duty to be paid on an instrument is kept open to be decided.
That's right.
It is without
And
prejudice.
this acceptance is subject to final decision of the speech.
Yes, of course.
That's not acceptance. Invocation will be done in the event it is.
And one more thing is that now the company, the NCL has passed the order in respect of the Mittal India Steel Limited Mills. Now they have changed this to private limited. So that private limited concept is no more there.
Who has given you
The third one, the private limited company.
the fresh bank guarantee was given? This.
Yes. So he just completely stranger to me.
Petitioner has given the fresh bank guarantee. My learned friends are now secured with the fresh bank guarantee.
You are a transferring company or
second.
The transferring company has simply changed its name following the requisite procedure. Yes.
Yes.
That has not been
Where is the
accepted by the
difficulty?
government. That has not been accepted till date.
No, not for the one. They have accepted the merger.
That has not
They
been
have accepted the amalgamation. They accepted the transfer. Now, if the transferring company changes its name following the provision of the company, that this does not change any
change of name. It does not invite any stamp duty. Sorry, I do not opine on that.
That is main
There
case.
is a concept of a merger and a concept of change in name.
He said that the change of name.
Difference.
He said that is change of name.
It is a case of a change of name, then
Because
I need not have.
Page 216 is the certificate of incorporation granted consequent on change of name. And this was disclosed in the petition itself. Page 216, please have a look.
Companies Act.
Section 18, Your Lordship.
Not subject to final decision of this case.
Both of you come on the next day to answer many queries.
Right, you are supported by some government support over Calcutta Court. I have with me, and I'll give it to you.
The first one, this is Girish Gupta.
Yes, ma'am. And then it was my lord the Chief Justice.
Upon change of name, what will be the status of the new company? The honorable Calcutta High Court.
Let us see that expression which you are using.
84
The
Calcutta.
expression which you are using is a very important expression you have to justify.
84 Calcutta, if I
It is
remember it.
simplicity a change of name
Or a change of
something else.
it's entity of the
Well, the question would be, question would be, Malad, whether, Malad, consequent on the Malad scheme of merger, Malad, there's a transfer. And even if there's a transfer, Malad, in view of Malad, the provision for remission.
That radio judgment, Bravo.
General Radio Appliances.
Radio appliances, 1990.
1988 or 86, probably. Well, I'm not pretty sure.
Voluntary and involuntary, you know
Yes.
the concept of a difference.
Yes, yes.
So that was done. Merger was considered to be.
Yes, Malad.
But that's why I did not say any or open my
No, no,
mouth.
Malad, here, Malad, there is a distinction here, which why, Malad, I'll let your lordship on. Malad, there is a recognition of the fact, Malad, that Malad, in such event, Malad, there will be a remission offer. So, Malad, this duty may not be applicable same all over again. 118 crores plus 47 crores already paid once by Malad ArcelorMittal India Private Limited. They want Malad again 118 crores from Malad, the new entity, which is Malad, in fact, the same Malad wine in a new bottle. Now, Malad, I'll address your lordship on that, and Malad, whether the provision for remission, which is available in such cases, is applicable in this case. Well, on that, I have to address your lordship. That is the main issue in the writ. And I'm conscious of, Malad, the judgments right from Justice Girish Gupta onwards, Malad, which later received acceptance of Malad subsequent judgments of our High Court, Malad Calcutta High Court, and Malad the Supreme.
In court is the Shalimar.
Yes. Shalimar Rope Works, I think.
Come ready. Come ready.
Well, in the meantime, Malad, let them not.
I think I had an occasion to argue before Justice Rashtrapati's division bench. That is in Bhagwati Prasad Ketai.
I'll look that up, and I don't remember that.
Similar point.
I know that your lordship has dealt with this question, but Malad.
I dealt with by sitting with Justice Pratap Kumar Ray.
Yes, that I do. And your lordship, Malad, has also Malad held whatever Malad had been held previously by Justice Girish. That was the view followed.
Keeping those larger issues open, today it is towards performance security, we are giving a condition. But performance security. And in terms of the interim order, this new company is operating the mines, and then for MDPA, they have. So that is the.
So alteration in the name, change of name is a one concept. The merger is another concept. So one cannot get confused in between these two.
That's it. Well, we are only praying temporarily that your lordship will allowed. Well, the subsisting bank guarantee which is for a much higher value, more than 100 crores in excess. Well, to be in operation, to be the performance security under the MDPI agreement, and will earlier guarantee to be released.
You have accepted the second one?
Yes. Yes. Well, on the 16th of June 2025, they have never raised any objection. Almost 1 year back.
We have made several players to substitute, we have not done that, we say it is not permissible. Unless and until you pay the stamp duty and other things.
that will also have to be, my lord, perhaps extended. Well, if your lordships have a look at the order of 12th March.
Why don't you file your pleading?
We have received the instruction yesterday, I will file my counter. On the next day, matter will be heard.
The respondent, sorry, the opposite parties, I always make a confusion because we are more accustomed to the word respondent is the opposite parties are directed to file their respective counter affidavits.
We kindly extend the interim order of 12th March.
The interim order granted earlier is extended. Great. Till next prepare. It's come ready with all the journal.
Yes.
Yes. Yes.
Special weekly list item number 1, 9709 of 2026.
Give him
a copy.
Yes, just
now.
Yes, just now.
Item number 2.
Who is appearing for the
Item number 3. Item number 4.
RC cancellation.
Item number 5.
Item number 5 says accidents. Item number 5, Lordship, it's not a single matter, it's related to place of business. We have to file our affidavit, Lordship. He has not filed a single document, supporting that the business is continuing.
Yes,
the counter affidavit by
1 week, Lordship. 1 week, but he has to supply some documents. He has not given any document in the respective Lordship.
I'm not the specific petition. Without any document. And there is a serious allegation against you that you are your place of business.
It's not written in the focus, let's say that no place of business.
It is there, Lordship. So, is there any
Then we are dismissing because we do not find any documents support their affidavit.
Only within 6 months of his registration. It's not written the no place for business.
It has not been given.
And Lordship, page 14, your Lordship. Page 14, annexure 3. Rule 21, a person does not do any business from declared place of the company. Annexure 3, your Lordship. It is there.
No one was written has not comment business.
Whatever, then yes.
But in the it is so close. In the order they have only written that
The allegation is not registered. You have not commenced the business within 6 months from the date of
it is order. It is only not commence the business. Not commence the business.
Counter affidavit by 1 week. We joined the within the morning. It will go within 1 week after the reopening.
Yes,
And let the matter be listed in the first week of
July. Item number 6.
the same.
Item 6 also asked us.
The same.
It is 6 months, your Lordship. 6 months.
yes 7.
Item 7.
Registration.
Item number 8.
Same suggestion.
Item number 9. RC. Item 973 4 paper. Item 10.
This item 10 and 11 RC cancellation.
Item 10 and 11. Item 12.
12 and 13, 73,
73 for the lot.
Item number 14.
14, 15 and 16, 73 for
14, 15 and 16.
It was there in it was there in print. No date fixed.
So देखिए पूरे weekly list. Item number 1. Sorry.
Matter related to
limited purpose matters. Very limited purpose matters.
So yesterday I said that
That's judicial. For vacation you want?
No. I know, you'll be twisting your argument. Because I know that the various of rules we are challenging here, the lordship in fact had applied the lordship mind, but because of procedural time today, if I can make a prayer for some interim writing.
what is the
Next day, lordship can protect us. Looking at the admitted person in the counter, rule 19, which they have admitted, kind of similar to their counter. They have admitted, what the challenge is? Challenge is rule, they have amended the accounting procedure rules, giving an unbridled power to the video to pass bills up to 10 lakhs. Your lordship has heard this matter earlier.
Okay.
But today, in the counter, they have admitted that in view of Rule 19, the same accounting procedure rules, that power of the video is subject to Rule 19. That much of interim protection we need. That's all. That is their admitted position.
Their admission, lordship.
But they're all admitted.
Yes, what you say?
my lord, in this case, we have filed counter. The amendment rule which was brought in, that was published in the Gazette, inviting public objection and all that. After that is over, rule has been made, and as per the provision of the Act, under 57(3), which has to lay before the assembly for some modification is necessary. So that is how it is
Not binding to force there.
My lord,
They implement its modification.
I have a question. But this is not enforced. According to you, it requires cabinet approval order or to be placed in the floor of the assembly house. Now, after the debate, it will be done, and thereafter it will go for a notification in the official budget. So it is still in the nascent stage of organization. Can you implement it? Right.
no, that can
Not be
That observation suffices. Only that observation.
let it come after petition. Let it come after petition. Das was doing it. We have got to assist and
That case, I think,
AG.
Yes, end of the matter.
Counter 7 file, let it come after vacation matter.
But so far as the accounting, everything, it has gone out from their hand.
Yes.
Kindly visualize.
Kindly see the affidavit, my lord. They are taking a stand before your lordship that it has not come into force. But kindly see today the affidavit, we have got a list of orders where the videos have been exercising their power in respect of the rules which has not come into force. Kindly see.
That attachment has to take instruction.
You said that it is not.
Yes, sir.
But let me interested in the Das, I'm saying it.
Where is he?
28-0, kindly see, ma'am.
Mr. Das?
Mr. Das, as to the matter, I with the AG in his honor, his court, my lord.
Yes.
He is asking the matter in Justice Dekhi's court, he is asking for state adjournment to come after vacation. Counter 7 filed and all.
Counter page 10, lordship.
Kindly see what they are counter.
So this is the affidavit, lordship. In
Counter, kindly see by
in writ petition, lordship, 27234. 27234, up to 25, lordship.
And sign it on counter then
27234, the 25.
kindly see para 15, madam. We are only seeking a protection to the extent they have admitted.
Para page 10, lordship, internal page 10. Page 10. Has to same thing. Two seven two three four.
206.
They have said that the supervisory power, this power remains with the Samiti and the chairman.
They have said, they have admitted this, but then they are acting contrary.
But what he is saying is not stated here.
That is there.
Page 10, Lordship, internal page 10, subpara. In this context, it is only submitted that the Orissa Panchayat Samiti Accounting Procedure Amendment 2025, which is published in the Panchayat Raj and Drinking Water Department, notification number so. In the meantime, it has been laid before the legislative on 1/12/25 for a period of 8 days during the 5th session of the 17th Odisha Legislative Assembly. The said rules shall be laid for further period of 6 days in the next session of the Assembly by operation of the Providence Act. Since the said amendment rules is yet to be taken the final step, no cause of action has been made out by the petitioners to maintain the present writ application, and thus the same being premature is liable to be dismissed. Then Lordship, page 12, their admission, they're quoting rule 90, and they are saying the power with the chairperson, and chairperson has the power to stop and to every Lordship. Para 12 Lordship, they quoted the provision 90.
But you have not said that it has not come into force.
Lordship, that is para.
That by operation of provisions of the Act, since the said amendment is yet to take a final step.
It has not taken a final step. That is their own stand.
But page 10, probably your Lordship is not holding that.
Who is
27234.
27234. 27234. Yes.
paragraph 8?
Page 10, Lordship. Page 10. Internal page.
By operation.
We can quote it, Mr. Das. That's a very specific stand taken, that it has not really taken a shape of a rules.
It has not suffered complete name now.
And it is their stand that no cause of action has accrued. So if the rules are not taken,
We say that the amended this, I do not know, this amendment rules, I do not know what he says about it.
That is the not 10 lakhs, which is 2 lakhs that says.
This by operation, the amendment rules is yet to take a final shape.
That's challenging.
That means it has not been notified.
It has not been notified, but giving
27234. 27254.
on field they are implementing it.
So that's you have not drafted.
Yes, ma'am.
You have drafted.
Page 10, last from the bottom. Nine lines from the bottom is there.
The said rules shall be relayed. After period of 6 days, in the next session of the assembly.
The mandate of this subject.
Of the proceedings of the act.
So you have not laid it, so it does not have the boards of law.
We kindly see 57 of the Panchayat Samiti rules.
You have to.
Yes, you have a power to make rules.
Yes.
Then you have a power to make an amendment. But by following the procedure, it has to be placed in the floor of the assembly.
Yes.
That you said you have not been able to do it.
But in fact, it was placed.
Then again, that was not. Further, after quotation, further. It is pertinent to note that as per sources mentioned, when the procedure from sources mentioned, that it is specified there in that. If the state legislature makes modifications during the laying process, the rules thereafter shall have effect in such modified form. We do not know what modified form it will come. That is your version. Your stand, specific stand.
But today's instruction from the department.
We do not know, we are on this counter affidavit. You have filed.
Yes, this was filed on 13/12/2025. Now, today's picture, my lord, this, in the meantime, it was placed before the 17th Odisha Legislative Assembly for 6 days. Then for subsequent days, it has already been taken effect. Today I got the instruction from the department, but from the Odisha Legislative Assembly, they have not received the specific.
No, sir. The difficulty is that this rule which you are talking about, this under section 57(3),
yes,
it can only be done by the government. And if any amendment or modification, if you want to bring in the subordinate legislation also, then that's to be done by the government.
You'll kindly see.
If you look at this paragraph at page 10, you'll say that it was done by the Panchayati Raj and the District Department by virtue of their own circular or notification.
Yes.
But this was supposed to be placed in the floor of the House of the Legislative Assembly.
But that is a requirement.
It was laid on 1/12/2025 for a period of 8 days during the first session of the 17th Legislative Assembly.
Yes.
Then the said rule shall be relayed.
Yes.
That means during that 8 days it was not passed.
No, but because it has to be placed for 14 days. That is the requirement under the rules.
Suppose if you have not, if a particular bill is sought to be laid, and the assembly did not debate on it, nor any decision has been taken thereupon, what will be the effect of that particular bill? Does it get automatically approved?
No.
That's why you say that since there would not be any discussion, it shall be relayed. Relayed when?
Relayed for further 6 days. For further period of
relayed for a further period of 6 days.
6 days means
means in the next session when it comes, it will be laid for a further period of 6 days. For 6 days, it will be there so that it is done. Then you say that till date it has not been relayed. No, by operation of law, it has not taken a final check.
But this counter affidavit was filed in the month of December. Then that the stand taken that it will be laid for further 6 days in the assembly. That whether that has been relayed or not, today's my instruction is it was laid and it has been passed. That is what they said. But the department has not received the proper information from the Odisha Legislative Assembly. So that is why they are not clear on the issue. So
That
yes.
means that has not been signed yet.
Yes.
And gazetted.
Apart from that, there is one more aspect. If you actually look at the counter again, kindly see page 12 of that very counter. In view of that further admission, kindly see page 12. That there can be an interim order referring to this rule 90, kindly similar, because that amended rule 16 and they are acting on rule 16, bypassing rule 90 is not correct. Kindly see page 12. They have reproduced rule 90.
Yes.
So all such amendments are subject to rule 90. If that kind of interim protection is given, that also will solve the issue. That will amount to finally decide the matter also. When the rule 90 is never amended, it's still continuing in the rule.
My lord,
Kindly see rule 91.
but the very conferment of power on the video.
It can't be
Since
rehoused rule
2007, kindly sir.
It can't be
Very
rehoused rule 90.
conferment of the power on the video to sign the check to 2 lakhs, so funds up to 2 lakhs was never the subject matter of challenge. It was way back in 2007.
Subject matter of challenge.
Now they have challenged, but it was never challenged from 2007. Now subsequent, by way of subsequent amendment, it was only enhanced from 2 lakhs to 10 lakhs.
But even 2 lakhs is subject to rule 90, 10 lakhs is subject to rule 90, everything is subject to rule 90. It is not rehoused rule 90. And besides that, if your lordship sees section 90 and 20 of the Purpose of the Act, the video is the subordinate to the chairman and the Shamiti. Executive, if I see the section 19 and 21, he is under the Act, he is subordinate. By rules, can you make him more powerful comparison to the Act?
No, that is
Can see section 19 and 20.
He is subordinate. So there is no dispute. He is not. Yes. That is undisputed, man. He is subordinate to the chairman.
Yes. Video shall be executive officer of the subdivision and subject to such rules as may be present in the function under the control of
Section 19
You are not very
the authorities are both in the chairman. Section 19 is very clear. Executive authority is subordinate based in the chairman.
You are giving an unfettered and unbridled power in the chairman.
And rule 90 is clear, man. Your lordship may look at rule 90. Check on payment. Your lordship may kindly see check on payment. The chairman of a committee may stop any payment by the block development officer for the reasons to be recorded in writing and place the matter before the committee or the standing committee. That power is not sacrosanct by the video. The lordship may kindly appreciate. But the lordship may, what I pray, my lord, so far as that rule is concerned,
We are saying that you are also taking shelter under 90 years.
Yes.
Implement 90.
Yes, that's all.
Exactly.
90 is already there in the provision.
Yes, that you implement 90. Yes, that will be applicable.
You are not against 90. They are also not
They are happy with the 90.
Yes, sir.
Not if
It should be disposed of.
Then there is no virus. They are challenging virus of the provision. So there is no virus. That is intra-virus. Let that be.
So they are happy that I do not want virus. If 90 is taken into consideration.
Only clarification.
90 will give only clarification will suffice.
Right, it is already there.
Okay.
In the statute.
Yes, all the matters. Let's keep it for orders on Monday.
Grateful.
Item number 2.
Next. Yes,
Item number 3.
Mr. Samantara will attend this case time tomorrow, my lord. It's the matter where next week.
Item 4.
Very pleasant. This is a matter, this is a petition, writ of warrant relating to the service condition of the opposite parties.
Then how it becomes, how it becomes the public interest?
No, my lord, it is never, it can never.
So it can, why it is appearing on the
It is inadvertently,
and this goes to which,
my lord,
determination this page?
no. While the matter is listed before the honorable single bench, the honorable single bench admitted that the court is aware of the established principle of law that in a service matter no peer lies except in a case of issuance of writ of quarrel. It is also observed that in the present case, the petitioner being a third party, this could doubt the maintainability of writ application before a single judge. As the petition is not an aided person, institution. It is admitted by the
Director registry, why does come?
it is inadvertently listed before this honorable.
The matter is wrongly listed before the court.
Item 5.
Yes, this PRL there is some issue of concerning basic civil amenity of road safety. In the HON'BLE and Culture road, what is there? Very similar annexure 1 minus. What is thousands of trucks are daily.
Now this is legal, I think.
Have you taken instruction?
I think taken from
Take
outside.
instruction in the next.
Item number 6.
Is your lordship. Good, short issue. If my lord could just take 123 in the interest of time, it will capture it. It is about the catastrophic disastrous consequences arising from the transportation of ammonium nitrate through vessels. Just have page 123, it captures the whole point. And this is by the Ministry of Ports itself. So it will just save the court's time. Page 123. In the interest of time, I'm relying on this. May I read below? I am directed to state that the Ministry of Commerce has highlighted concerns regarding the safety at ports while handling ammonium nitrate. It has been reported that shipments of nitrate, the next word is very important, averaging between 15,000 to 20,000 tons per vessel are being imported into Indian ports. The unloading process from the ship typically takes a few weeks, during which time the vessels effectively become temporary storage facilities. The Ministry of Ports plays a vital role in enforcing rules under the Ammonium Nitrate Rules 2012 within port areas. It is prudent to reinforce existing safety measures and ensure strict compliance with the regulation for handling ammonium nitrate at all ports. But just skip this. Now kindly have Roman 5. Same at the bottom of the page. Ships laden with ammonium nitrate should not be permitted to stay overnight at the jetty with more than 5,000 MT. The ammonium nitrate laden ships may be moved away from the port area to the mid-sea anchorage after the day's operation gets over and to resume discharge operations next day. Additionally, it is important to acknowledge that past incidents involving ammonium nitrate. Yes, exactly.
If there is anything happened, then it may cause a disaster.
Absolutely, I'm grateful.
This is what they also suggest.
Yes, and what I've captured at page 10, all the historical incidents, including in India, and the most important point, can you just bear with me for just 1 minute? This is significant. Today there is a 258% increase between 2022 to 24-25. There are no port safety handling practices at all. They're not trained for this purpose. It's a ticking time bomb with catastrophic consequences. The Disaster Management Act under Section 35 empowers the central government immediately to take measures to deal with it. Not done. 15 representations have been made. Now with the geopolitical situation, Iran and Russia facing sanctions are sending all this our way. So not more than 5,000 metric tons should be carried by the ships. That also in a single day. And then they hold it in storage overnight. This is exactly what will result in this mishap. So, this requires some urgent remediation and no better than the Ministry of Ports flagging it, but then not doing anything, which is their duty under 35 of
Who is representing the central government? GST.
Without looking at scaremongering, my learned friend rightly says 20,000 tons would be half of Hiroshima. That's the potency. There is critical infrastructure, human lives, environment, all of that, my lord, with greatest of respect, is at peril. And this is, my lord, their own recognition of the issue, but not addressed.
I understand. They wanted that you should go immediately in the night and enter in the mid
Yes,
sea.
exactly. About 10 kilometers into the sea, not at the port.
Still the I think marine life will also be at peril.
Absolutely. We don't just have page 31. Just see the alarming
So
figures.
what is doing? Who is there is a Paradip port authorities. Have you served why don't you serve the copy first?
But we serve the union, which is the
No, sir. At least any public interest litigation or a rate must show that you have served the copy. Who is appearing? Paradip port.
not a present apparently.
Yes.
Mr. DSG.
Yes, ma'am.
This is a serious issue where you cannot show any kind of a complacency in this regard.
Yes, I will take instruction, my lord. Yes. Government
There is a Paradip port.
Yes.
No, the notice has to go.
For them, notice has to go.
Paradip Port,
Give a notice.
may issue
Let
notice.
them come with the thing. Otherwise, we will say that you'll have to ensure the due implementation of this advisory issued by the port authority.
Yes, it is appropriate also. I can't say because of the.
Is a Ministry of Ports.
It was shipping in ports and shipping.
And for the time being, nothing. If we carry 1,000 metric ton of ammonium nitrate, so whatever the time you do it, but in the night, take it back in the mid-sea.
Get it. And mid-sea anchorage.
Yes.
Page 174, the remedial solutions have also been set out by us for the court's kind consideration.
That has to be done.
Well, many repetitions are there.
Again, it will involve the charging of the port fees.
Exactly.
Then what will happen? If they have to anchor in the mid-sea, that for that period, can they charge the port fees?
With greatest of respect, the considerations here are, as your lordship said,
I understand. That's why I'm saying that it also affects the government exchequer.
My lord, what I'm requesting.
So other safety measures can be resorted to.
Yes. Page one.
That is what is more important.
Yes.
What I'm saying.
Balancing the all rights.
Correct.
What I'm praying, my lord.
We understand. We know the catastrophic effect of it that will come. But can there be any other safety measures which can be ensured without meddling with the government exchequer as well?
Quantum is increased by 250. Made good in that sense, but here their own advisory is not being effective. They have noticed the problem.
That is what I'm saying.
Correct.
That's an advisory. Now the decision this advisory must convert into a policy decision.
Binding policy
decision. So that is what we were thinking about.
Yes. But if your lordship could just indicate that it will aid things. Otherwise, as your lordship knows, it will go into a cold storage.
The public interest, the instinct
the problem.
We're carrying more than 5,000 metric. I says now one of which I says carrying more.
So deeply.
I can evaluate very important matter, which was 15 day matter. It was right around 1